Now let us look at different schools of jurisprudence or the different schools of law. I would rather prefer to call it different schools of law because that gives us an idea why these are called schools. These are called schools because these are some of the streams of broad understanding about the notion of law from time to time. Now, under this different broad understanding of law or the streams of understanding about law, we have different people who are said to be the proponents or who are said to be the advocates of these particular schools, and it is their contribution to the growth of law and jurisprudence which is so significant for every one of us to look at. To start with, let me take you to the analytical imperative school of law, and it is also called as the positivist school. As the very name suggests, you have this understanding in this particular stream of law that the main concern of law is actually the law which is found and not the ideal law. If I have to explain to it further, positive sense of the law implies that law concentrate on what the law is, not what the law ought to be. And that is why I say it is primarily concerned with the law as it is seen, not law as it should be. Now, it was primarily dominant in England, and the primary motto of analytical school is ubi civitas ivi lex. That means where there is state, there will not be anarchy. So, what is being implicit in this particular statement is state is a necessary evil, because it is only through the state law may be exercised. When I say that through the state, that means the instrumentality of the state is important when it is to do with the exercise of law. There were different people who were associated with this school, to namely Bentham, Austin, Hart, Kelson are noted proponents of this particular analytical imperative school. Now, when you look at the contribution of Bentham, we find that he distinguishes expositional jurisprudence from sensorial jurisprudence. Now, what do you mean by expositional jurisprudence? By expositional, he meant what the law is, and from sensorial, he meant was what the law ought to be. As I have already told you, now this particular school concentrated on what the law is rather than how the law ought to be and how the law should be. His concept of law is imperative. When I say imperative, it implies that law is nothing but an assembly of signs, declaration of volition conceived or adopted by sovereign in a state. And as he is acclaimed for his theory of pleasure and pain, the utilitarian theory, when he applied this particular utilitarian theory in the whole domain of law, it was declared to be one of the principles of utilitarianism that the proper end of every law is the promotion of the greatest happiness of the greatest number. That is why, when you look at the contribution of Bentham, we can say that the function of law, as according to him, must be to meet the ends of subsistence, abundance, equality, and maintain security, and that too, as I've already stated, the greatest happiness of the greatest number. Now, another very important proponent of this particular school was John Austin. In fact, he is called the father of analytical positivism. Now, he had this particular book, The Province of Jurisprudence Determined. Now, what is the understanding of John Austin? Now, John Austin's understanding is that the basis of jurisprudence, or the basis of law, was the command of the sovereign. Now, why he called it a positive school? Because it was positive in a sense that it is a general rule of conduct laid down by political superior to a political inferior. Now, when we say that there has to be a political superior and a political inferior, that means there is an element of hierarchy involved, and that sovereign has got every right to give command or the issue command, and in case the command is not obeyed, what is implicit in that is the threat of punishment or the threat of sanction. Now, for Austin, that is very important. That means the instrumentality of state, the political superior or the command of the sovereign, and the inferior, and all that of sanction or the punishment which it includes. Now, to him, the positivism it's called just positivism. That means law simply and strictly so-called law set by political superiors to political inferiors. Now, hence Austin defines that only the legal system of the civilized societies can become the proper subject matter of jurisprudence, because only in those societies there is a machinery for administration of the law, or what we call the state machinery. Now, another influential person under the school of positivism or the positive school was called Hart. Now, he has written an influential book called The Concept of Law, where he in fact criticized Austin's theory. Now, according to Hart, the law consists of the rules which are of broad application and non-optional character, but which are at the same time amenable to formalization, legislation, and adjudication. To him, law is concerned with obligation rather than coercion. Now, there is a difference between the way Hart conceptualized about law and Austin did that. Now, for Austin, it was an element of threat for sanction, or what is implicit is also an element of coercion. But for Hart, what he was trying to say that there was an obligation that is implicit, and when that obligation is there, people feel that they will show their obedience to law. That is why they are saying that an obligation is similar to a duty. The idea of obligation, according to Hart, means that a rule is accepted by the people, that is, a rule is internalized and not habitually obeyed as conceived by Austin. Now, it is very important to see the difference between the understanding of law from the Austinian perspective and the understanding of law from the Hart's perspective. Now, when Hart said that there is a kind of intrinsic obligation, or the people must feel that they would show their obedience to law, that means it is not a coercive force altogether. Now, thereby, he emphasized on both the internal and external aspects of rules. The former implies a kind of an obligation. There is no compulsion involved, where the latter implies being obliged under compulsion. Now, according to Hart, the predictive theory of Austin excluded the internal aspects of rules and dealt only with the external aspects of rules. That means the point of criticism for Hart was that for Hart against Austin was that internal aspects, people must feel that they have a duty. That was perhaps missing out in the Austin's formalization or Austin conception of law and jurisprudence. Now, after looking at the contribution of Hart, we also need to look at the contribution of another very important and interesting jurist called Kelsen. Now, he gave a very interesting theory, and this is called the pure theory of law. And let me explain to you what is this pure theory of law. Now, this pure theory of law is a theory which is free from social, historical, political, and psychological influences, etc. It is a pure theory because it only describes the law and attempts to eliminate from the objects of the description everything that is strictly not law. That means the Kelsen is looking at law as something, I would say that not in association with other aspects, but something in elimination from all other aspects. That means it's in a pure form. Law not as an interface with the other aspects of society, but law in elimination of other important aspects. And to him, it perhaps gave him a better understanding of the law and jurisprudence. Now, to Kelsen, law as an order of human behavior, these are primarily the proposition. That means if X happens, Y ought to happen. Now, there is a law which says that if somebody commits this particular offense, he would be punishable with 7 years of imprisonment. To Kelsen, that is the law. He does not intend to go beyond that particular prescription or the oath proposition. So, that is one way of looking at what the law and jurisprudence is all about. Now, he also says that law is not command of a personal sovereign, but hypothetical judgment, which visits with a sanction for the non-observance of the conduct prescribed, and not essentially or exclusively law is a commanding or of imperative character. Now, broadly, we can say that the Kelsen contribution was primarily to look at law as something, as a separate entity. It is some propositions which says that if it happens, the result will be that. So he wants to confine his whole theory or the thesis into that. Now, after having looked at this positivist approach towards law as it is, not law as it ought to be or should be, and law in its pure form, and so on and so forth, let us look at the next school of law, what we call it historical school. Now, what is the historical school all about? Now, the historical school, the significance lies in the fact that it sees law as a process of evolution. Law as a process of historical evolution. It is again trying to look at not the law, what the law is, but the very functional aspect of law. That means, what are the actual circumstances which were important or which gave rise to the necessity for having law and legal institutions? That means, it also looks at man who has to show his obedience to law, not in isolation but in association with others. Now, what are the important factors, the culmination of which gave rise to the need for law in human civilization? The school emphasized that historical factors influence the origin, formation and development of laws. Law is found, not made. Laws are not of universal application. As tradition and custom determine the law, laws are rules consisting partly of social habits and partly of experience. And in fact, Germany was the cradle of the school, and somebody called Savigny is the main exponent. And what to savingly the whole issue was that, the whole understanding of the law was that the nature of a particular system of law was nothing but a reflection of the spirit of the people who evolved it. That means law changes from civilization to civilization, law changes from the society to society, from the history to history, and so on and so forth. It is nothing but the law is, the life of law is the life of people. It is the product of people's life. And it can only be understood well by tracing the history of people in the community or in the society at large. Now, another very important person who contributed to the historical school was called Maini. And for him, there are 4 stages in the evolution of law, the historical whole aspect of law. Number 1 was the laws were made by the commands of the ruler. Number 2 was crystallization of commands into customary law. Number 3 was administration of custom by priest, etc. And number 4 was the final stage, that's the codification of law. Now, if you look at the way the laws were codified in Indian context from the time of Dharmasastras, again during the medieval time, the Islamic law, then finally the Britishers felt that no, there was a need to codify the law, and this whole process is nothing but the historical process. I think the stages that many talk about, it fits in well in the Indian context. And the last school that I intend to discuss with you today is the Sociological School. That is where, there's a subtopic in your syllabus which talks about the relation between law and society. So this particular school, Sociological School, which says that law is nothing but the social engineering. The lawyers are primarily concerned with addressing different problems and the issues of the society from time to time. And what they do is nothing but the engineering of these problems and issues, and that is why lawyers are called as social engineers. Now, how does an important contributor of this particular school called Roscoe Pound, what exactly he stated about this particular sociological school? Let me read out for you, and I quote. Law is not set of rules, but is a method of or technique for harmonizing conflicting social interests. The task of law, in his opinion, is to build an effective structure of society as possible by satisfying the maximum wants with the minimum of friction and waste. This will involve adjustment of human relations, ordering of human behavior, and above all, balancing of competing interests in the society, and that is what he meant by social engineering. That means what he wanted to describe and explain from the whole very important concept of social engineering was that there's conflicting interests in the society. As long as there is society, there are conflicts are bound to happen. But how does we set a certain rules, set a certain rules of the society whereby there will be less of conflict, less of friction, but then more of joy, more of enjoyment, and it is through law only. That's why we say that in fact the law is the greatest gift of human civilization. Because of law, everyone, irrespective of the position in the societal hierarchy, can enjoy the fruits of civilization, enjoy the fruits of society. And the sociological school, an important contributor being Roscoe Pound, is very, very relevant when we try and see the relation between law and society. Now, the media law that you people are directly engaged with, nothing but a public law, and it impacts on the society. So when we see the media law, we also need to see how law impacts on the media, and how does the changes in the media also impacts on in the law, impacts on the law at a larger scale, because the law that being enacted for the purpose of regulation of the media, or what we call it, different to address different issues relating to media, also to some extent, or to a large extent in fact, have to ensure that there is a proper social order in the society, and it also has to have a societal object, that is what we call it, in just an equitable society. So that is what the Sociological School stands for. And I think I'll stop here today, and tomorrow we'll look at the other important aspects of law and media law. Thank you so much.